I happened to bump into Chief Ed John just outside, and I apologize for losing myself. And he reminded me, he said, "No, you weren't." He said, "You were just ahead of yourself." And so I'll take this opportunity once again to thank the panel, and also take this opportunity to thank you. And I think that many of the things that were raised in the panel have been echoed throughout the entire day. Issues around self-determination, issues around reconciliation, issues around change, issues largely that relate to the very reasons we're here, which is to join arms and to form allyships and networks will change the society in which we live in. In saying that, we have had amazing discussion today, and we've had amazing ideas put forth, and leading into the ending, towards the ending of the day, I feel very privileged to have Chief Ed John come and to talk with us, to give us the keynote address for the day. Ed John is, like all of the speakers here, is a person who is passionate about human rights. He's a man who has brought great changes, and he's a man that indeed is an ally to us all. Ed John, as I'd mentioned earlier, is a hereditary chief of the Tzitzit Nation. He sits on a variety of different boards and is very much involved with the Permanent Forum on the Indigenous Peoples at the United Nations. He's a person that has influenced me. He's a person that influenced many people in this room. And I'm sure he's going to be a person who will continue to influence you after his discussion. Ed John. Thanks, Chief. Have you got water? Do you want me to bring water for you? Okay.
Given today's discussion, we're going to begin with a short clip here. It's about 4 minutes. Just bear with me, please. Thank you.
There is something that breaks inside of us when we go through a trauma, an atrocity, and we turn for help to people, and they turn their faces away.
For years, we Canadians have turned our faces away from the reality of residential schools. Over 150,000 Aboriginal children were forcibly taken from their families in order to assimilate them into white European society, in order to kill the Indian in the child. We turned our faces away as Aboriginal students were subjected to sexual, physical, emotional, and psychological abuse. We turned our faces away as thousands of students died in residential schools. They died from TB, the Spanish flu, malnutrition, suicide, accidents such as drowning, fire or exposure, or they died when they ran away. We turned our faces away for decades. It wasn't until 1996 that the last school finally closed. Today, we refuse to turn our faces away. Today, we see and we acknowledge what has happened. Today, it matters.
It matters as a Sikh because we are a faith that was founded in this concept of social justice. You know, standing up for the rights of all, not just ourselves, but for the rights of all human beings.
We have been fighting injustice and other humanitarian issues for the last centuries.
As Sikhs, we can relate to the First Nations experience. We too have people turn their faces away as we try to share what we've been through. We know what it's like to be unrecognized. whether it's our mother tongue, our distinct identity, or our faith. We have also lost generations, and we too know what it's like to be denied the opportunity for truth-telling.
It matters as a Canadian because it's part of our history. And we need to understand our entire history. The First Nations residential school experience represents one of the worst. And so if we can recognize where we went wrong, we can set about making it right.
There is something incredibly empowering when we turn to someone and they listen, and they look into our eyes and they acknowledge what it was that happened to us. And so it matters, this whole process of the Truth and Reconciliation Commission, this whole process of truth-telling, of listening to what's happened, it matters because I don't think it's possible to heal without someone being willing to listen to someone's nightmare.
Thank you. I wanted to to thank York University and this particular law school, through law to justice, as your coat of arms says. I wanted to end where Willie left us this morning, where he started. And this video clip is about our people reaching out and others responding to this horrific chapter in our history. A chapter in our history that we collectively share, we collectively own, even though we were the only ones in those residential schools. It was a matter of public policy in this country. As the Prime Minister said in his apology in 2008, to kill the Indian in the child. Well, we're here still, and certainly not going anywhere. So, as we come to grips with this reality, because our people need to move on, we cannot stay in this place. We cannot afford to be there. We need to move our people out of it. And how do we do it? And we need to understand this sordid relationship that we've had that's too often not understood or not even seen, or if it is seen, people turn their face away. The Sikh were turned away in the west coast of this country when they came to immigrate into Canada. They were not welcome. The Komagata Maru, the ship that they came on, stood on shore on the coast of British Columbia, coast of Canada, and eventually had to return to India. The Chinese, when they immigrated here, were not allowed to live in the nearby towns. They had to either live in Chinatown or with the Indian people, and our people welcomed the Chinese on the west coast when they arrived, and there was a head tax. We know that apology. They were not allowed to vote in elections like we were not allowed to vote in elections. The Japanese in World War II were interned, their fishing boats were taken, and they were taken into communities far away from the coast of British Columbia into the Kootenays. And I think that's part of the collective history that we need to understand and to ensure that we don't see that happen. And how do we do that? Through the recognition and acceptance of human rights standards that are so important for our survival, our dignity and well-being. See, that declaration on the rights of Indigenous peoples is not just our declaration as Indigenous peoples, it's your declaration as well. So it's about your survival, about your dignity and your well-being as well. We put and we fought for that because it gave us a purpose. That declaration revolves around the purpose in Article 43. Minimum standards for the survival, dignity, and well-being of the world's indigenous peoples. 370 million, at least, at a very minimum, indigenous peoples globally. And as I look at the Declaration, 20 years plus in the making, I mean, it's a human rights instrument that took a long time to develop. I mean, we've seen international conventions that have been developed very quickly, relatively speaking. The convention on the disappeared did not take very long. Many different international instruments were within that 23-year period developed while we argued and talked with government and state officials, United Nations officials, to move this issue forward. Former Justice Louise Arbour from the Supreme Court of Canada was the High Commissioner in Geneva, gave instructions to our staff to begin to work on this particular declaration in earnest. Canada was a member of the Human Rights Council. And when the term for renewal came up, because she was critical of Canada's position, she lost the opportunity to be reappointed. Some people sacrificed. She was one of them. And I think we need to know the many, many sacrifices that were made. And I'm really thankful for Amnesty International, Quakers, many other non-governmental organizations that are not Indigenous who were there with us as we fought, well, firstly among ourselves as Indigenous peoples, because we wanted to make sure we got the right message. But then with governments, you know, it was a struggle because many states simply did not accept the fact that there were Indigenous peoples still around in their own respective regions or states, or even in places like Canada and the US, that we had vanished, that the Indian in the child was completed. So that video was really to show that efforts are being undertaken now. What can I do? The question is, what are the Sikhs doing? It's a good example of what can happen. And I wanted to say, as an Indigenous leader and a survivor of an Indian residential school, I never really understood. We were children. And through us, as children, our peoples, our ways, our cultures, our languages were to die. That was the policy of government, that we were the instrument of our own demise. There's some genius in that, you know, it's pretty cynical, but that was the plan. But you see, we came from the bush like Romeo. I was born in a tent on the side of a lake. And we grew up on the land, and we were taught about the land. We were taught about our relationships to each other, and we were taught about our relationships with everything around us. What was that relationship when we took a plant for medicine? We just simply didn't grab that plant and throw it in a pot and make some medicine out of it. We honored that plant, taking its life. It has a life, we are told and taught by our elders. When you take that, you honor that life, and you pray. You have a prayer taking that particular plant, that it would give you power to heal your body. And you return a gift to acknowledge that you have taken that. When you go hunting, it's the same thing. That there's a very distinct relationship, and I think in this modernization and the modern world, that relationship is broken. Everything becomes commodity. A tree becomes fiber. A salmon in the ocean becomes a piece. That somehow we commodify everything and alienate ourselves from our responsibilities to Mother Earth, to everything around us, to each other. So I said Article 43 is, I would say, the purpose of the Declaration. Article 3, or 43, Article 3 is really the heart of the Declaration, the right to self-determination as peoples, to exist as Indigenous peoples with our cultures, our languages. Nothing wrong with that. But the one that's really, to me, an important provision, Article 25, that we have a sacred responsibility to the land, or that we have this spiritual connection to the land and we have a responsibility. The word responsibility is in the Declaration. To future generations. I want to read that. Indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationship with their traditionally owned or otherwise occupied and used lands, territories, waters, and coastal seas, and other resources, and to uphold their responsibilities to future generations in this regard. That word, the word responsibilities, it doesn't talk about rights. It talks about the responsibilities, and it's reflected in the teachings in many, perhaps all of our nations as Indigenous peoples, that the first teachings that you're given are ones dealing with responsibilities. The elders didn't get up and talk to you about the rights that you had. They talked about your responsibilities. Because now, in this generation, between ourselves and the next generation, and the generation after that, and our parents and grandparents, we're here at this moment. And what is that responsibility that we have? And how do we know what that responsibility is except to reach out and to understand and to listen to the teachings of the elders? And that's so fundamentally important, how those teachings are shared. And we're losing that in many ways. Our languages, a direct result of Indian residential schools, our languages are dying. The Secretary General of the United Nations 2 years ago said, 1 Indigenous language dies every 2 weeks. So it doesn't look that good when you look at it from that perspective. But you see, as leaders, we need to have optimism and we need to have a sense of hope. We cannot move forward in this dark place where there's hopelessness and despair because it's taken too many of our people's lives. Many of the young children that I went to, the Indian residential schools, they're all gone. Suicides, alcohol, accidents, you name it. Shootings, murders. All young. And we see that. So we need to turn that around. But it's not without a struggle. I cannot for the life of me understand sometimes the policy of the state in this country, for example, where they, as Jennifer was saying, you know, the state has 700 lawyers and most of those are on Aboriginal files. 500 out of the 700 with a $92 million budget. There is not one case in this country that has declared that Indigenous peoples or First Nations have Aboriginal title to 1 square inch of land. In the preamble to the Declaration, it talks about notions of superiority, the principles of discovery. And we think that it's an old notion, the doctrine of discovery, as between European nations, was simply a principle of international law that gave the founding, as it were, or the exploring country, the right to take dominion over lands in the name of a king or queen in Europe. That was a law between themselves. And in doing so, they went out not just in the Americas, in Africa and Asia and other parts of the world to apply that principle, the doctrine of discovery. It did two things. One, it affirmed the assertion of sovereignty of the state that was exploring or founding the lands, and then taking possession of those lands in the name of the king or the queen, as the case may be. At the very same time, it undermined the authority of the indigenous peoples, political authority of their lands, the legal authority to their lands, and dispossessed it to the crown. Now, this principle was explored firstly in a number of cases in the Chief Justice Marshall of the U.S. Supreme Court, where this doctrine of discovery was applied, and the doctrine was applied in this way, that it undermined the sovereign authority of the indigenous peoples. And what they had left was this notion of a personal and usufructory right. When I first read that, I felt kind of embarrassed because it sounded like bad words. And it turned out they were bad words in a different sense. Those principles from Chief Justice Marshall were then applied in the very first case in Canada, St. Catharines Milling, in 1888 by the Judicial Committee of the Privy Council. And it involved Treaty Number 3, the Northwest Angle Treaty, the Treaty 3 area. That treaty had been just signed recently, prior to 1888. It was a fight between the government of Ontario and the government of Canada as who had the beneficial interest in the timber so that they could exploit the timber resources. Canada claimed they had the beneficial interest. Ontario claimed they had the beneficial interest. And in order to get there, they had to take a look at Treaty Number 3 and what it said. And in doing so, the Privy Council applied the doctrine of discovery, and the Treaty 3 tribes were nowhere in the court case. They were not represented, they were not a party in the court case, yet somehow their treaty was being determined and defined by this case between two fighting governments. That was in 1888. In at least 44 cases since then, that doctrine has been routinely referenced or applied by courts in this country, without the benefit of any legal argument. The latest case was in June last year, June 2012, from the Court of Appeal in British Columbia, where the doctrine or the principle of discovery was applied to affirm Crown authority, firstly, and secondly, to deny the Chilcotin peoples, the indigenous peoples, had any title to their territories, to their traditional territories. The Court of Appeal said, well, over there where you stood on a rock, or in the narrow defiles you walked between one place to another, or in the buffalo jumps, and we don't have buffaloes in British Columbia, that you might have in those small spots Aboriginal title. And that's, after 339 days of trial, countless millions by the Chilcotin people spent in advancing, through their elders and expert evidence, the nature of their rights. And the Court of Appeal says, geez, you didn't really show intensive use of this territory, so you can't really prove that you have territory-wide rights or title to to your entire Chilcotin territory, but you might have something over here in this small spot over here in that small spot. So that principle is alive and well. This case is now being appealed to the Supreme Court of Canada in November. It's a very important case because we think that it will be probably the first time that the court at the highest level in this country will decide that there is Aboriginal title still in existence and still applicable and alive and well in First Nations territories. See, and it's a part of the pattern of Crown conduct. Whether it's in negotiations or litigation, there's a history of denial, notwithstanding Section 35, that Aboriginal and treaty rights are recognized and affirmed. Those are the words. The Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. 17 words. We get 17 words in the Constitution. So we've been fighting at least 40 cases to the Supreme Court to figure out what those words mean. And to their credit, the courts have, they're not really sure because they're determining what the nature of this section is. And they say, well, it's got common law in there, but it also has Indigenous laws in it. Aboriginal laws, whatever they may be, should be given equal weight to common law. The problem is this: how many lawyers and how many judges know what Indigenous laws are? It's not taught in the law school and it's not practiced in the courts. So how are they able to determine what the Chilcotin laws are with respect to their territory? The elders and the expert evidence supports what their laws are to their lands and territories and resources. But somehow the court seems to think it's not enough. 339 days of trial and evidence, not enough. Millions of dollars spent in the Delgamuukw-Gisdaywa trial, similar number of days, expensive, time-consuming, costly. And the Supreme Court of Canada could not find its way to declare that the Gitxsan and the Wet'suwet'en had Aboriginal title to their territory. They couldn't do it. They said, here's the law, go back to trial. Marshall and Bernard, case from the East Coast, one witness. It failed on the basis that there was not sufficient evidence to find facts that would support Aboriginal title. It wasn't sufficient for the courts to make that determination. In 1973, 40 years ago now, the Nisga'a case went to the Supreme Court of Canada on the question of Aboriginal title on an agreed statement of facts, very short statement. The court could not make a determination of the existence of Aboriginal title in Nisga'a territory, but they did say that Aboriginal title was not extinguished. See, and so Section 35 says, recognized and affirmed. Aboriginal rights includes Aboriginal title, recognized and affirmed. But the government's position, curiously enough, is this. In negotiations and in litigation, they deny that you have title or you have rights. You have to prove it exists first. And it's got to be, there's a blueberry patch over there, you got to prove that you picked blueberries over there intensively. Oh, there's a raspberry patch over there, you got to go pick raspberries, you got to prove it that you've done it on an intensive basis. I was reading in Bernard and Marshall about common law possession of lands. somebody sitting on a marsh shore shooting across the marsh with a gun could determine that that person has common law possession of that marsh. So there seems to be different standards and I think the court is struggling trying to understand it, because the consequences of finding title and declaring the existence of Aboriginal title is important to us, and it's important to this country. But in British Columbia in 1846, the Crown asserted sovereignty. And in the 1850s, issued proclamations and ordinances to take possession of our lands and territories. No notice, no one knew, no agreement, no compensation, nothing. Simply ordinances and proclamation. February 14th, 1859, James Douglas, the first governor of the province, issues a proclamation. All lands and resources and mines and minerals therein, all lands and mines and minerals therein belong to the Crown in fee. Just like that. So, what we have been doing at the international level, we've been at the political table, we've been at the negotiating table, we've been at the courts, we've been very litigious in British Columbia. So we've taken this into the international arena as well. And surprising that Indigenous peoples globally are facing these very same principles, like the doctrine of discovery in terra nullius, that the land is empty and there's no one there and you can go in and take it in the name of the king or the queen. So, my friend, the late Chief Joe Mathias, and another friend, Gary Absley, put together this article called Conspiracy of Laws. And in it, they compiled laws in British Columbia and Canada that served to undermine Indigenous people's abilities, the pattern of Crown conduct. For example, in the early mid-1920s, 1924, 1925, they issued a law that said Indian people could not hire lawyers to pursue land claims. That was not repealed until around the mid-1950s. In 1886, they outlawed potlatches and sundancing, so important to the prairie people, sundancing. Potlatches is the essence of our laws on the West Coast. Our political, legal structures are built into our system of laws. Those were outlawed. Those laws were not repealed until the mid-1950s. Many such laws were in the books, and it reflected a pattern of and an approach of this state, of this country and its history of subjugating and denying the rights of Indigenous peoples. It went further. Governments, Indigenous governments, traditional governments were outlawed, and the Indian Act came into place, and no support for the authority of traditional forms of government. So we had the Indian Act setting up bands and band councils with limited authority. So there were very deliberate attempts and efforts made to do away with the Indian problem once and for all, as it's been recorded. So the declaration, the instrument, the United Nations Convention on the Elimination of Racial Discrimination, many other instruments like that are important. The rights, the American Declaration on the Rights and Duties of Man, which Indigenous peoples in the Americas have been using to fight for land rights in the Americas, have been successful in the Latin American countries. And so where we find ourselves is at this stage right now, we're in a huge battle for the recognition of Aboriginal title in this country, in the courts. We've tried it through negotiations, have not been successful. Nowhere in any agreement you will see recognition of Aboriginal title in a land agreement in this country. Sparrow won the right to fish for food, social, and ceremonial purposes. Section 35. You will not see an Aboriginal right recognized as such in any agreement across this country anywhere. East Coast, West Coast, North, South, in freshwater fisheries. So that's where I think we find ourselves right now. But you know, there is a sense of, like, you have to find a silver lining somewhere, and the optimism, because this has been a long struggle. And now we're starting to see that there is some light somewhere. Maybe it's at the end of the tunnel, or maybe it's a silver lining somewhere in the clouds, this dark period in our history. But it's not been so easy as we found. And we found that Indigenous peoples internationally are very much in the same situation. Not entirely in the same kind of a situation. The Maoris in New Zealand, for example, are a slightly different position than, say, where we are. But we've had to take these steps. It was no surprise to me that we saw Idle No More last winter, gaining the momentum and strength that it did. The hunger strike on Victoria Island. Willie and I went there to visit with Teresa Spence and Mr. Robinson, I think, the two who were on a hunger strike there. Because there seems to be, Bill C-38 and Bill C-45 taken together really, is a culmination, an ongoing assault on the rights of our peoples. And we see now on the West Coast in Alberta, we have the huge tar sands, oil sands development taking place, downstream impacts in the territory where it's being developed, proposed pipelines to the West Coast, refineries on the West Coast, tanker traffic offshore. 4 points of impacts. And the Prime Minister has declared that in the national interest. But what's happening now is because of court decisions, the legal duties of the Crown and industry, but the Crown in particular, to consult with and accommodate First Nations peoples. And we've managed to lever that into a position of strength. We've done that through the courts, but we've done that also by going international and telling our stories in places like China, Japan, about who we are as Indigenous peoples, that we're still here. China, incidentally, was one of the countries which supported the declaration and the adoption of that particular provision or that particular instrument. So it continues. The three mechanisms, expert mechanism, the UN Permanent Forum and the rights of UN Permanent Forum and the rights of Indigenous peoples. The expert mechanism of the rights of Indigenous people, a special rapporteur on the rights of Indigenous peoples. I'm using the Permanent Forum and the rights of Indigenous peoples because I think it will be approved. The name change will be approved this summer, this July, by the Economic and Social Council when they consider our report from last May. So internationally and locally, this instrument, this UN declaration, there are not too many places where you go in the indigenous world where they haven't heard about it. I was in a mining conference in Arizona put on by James Anaya, the special rapporteur, and the mining executive came up and talked to me and said, I was in a jungle over there in Asia somewhere, and these little people came up to me and they were talking about free, prior, and informed consent and the UN Declaration and everything. And where the hell did they find out about this declaration? People know about it. And so we continually take advantage of opportunities like this. And thank you to the university here for giving us this space and time to share with students like yourselves. I know you're all here because your professor is still here. Otherwise, I'd be like you. I'd be gone at 4 o'clock or maybe 3 o'clock. But having said that, I want to really thank the university for putting this on and those who helped organize this and the incredible presenters today. My heart was completely broken again listening to the survivors. Willie, myself, and others we understand what they're talking about. Our hearts cry with them because we know what they're going through as they're sitting here talking about their experiences, how important it was, and to thank them from the bottom of our hearts for sharing their stories with us. Willie, Willie is our international man. He's been at this game longer than every one of us have. How much of a contribution he's made to our peoples and the depth of experience and knowledge that he brings to this, and our friends from Quakers, Amnesty, Ellen, Paul Joff. I am never sure who he represents. It could be James Bay Cree, it could be Amnesty, it could be Quakers, but so many tremendous people. But I think the challenge is this. In these institutions, and I want to conclude by what former Chief Justice Lance Finch in British Columbia, the Court of Appeal, said, that we do not know what Indigenous laws are, and we need to understand. Somebody needs to teach us. We have a duty to learn, he said, and we need our institutions like our universities and our law schools to educate our young lawyers and young academics about what Indigenous laws are, so that we could give weight to those, we could understand them and apply them as we apply common law. And I think that's where we're headed, and that's where we will go down the road. So it's not such a scary place after all. I think it's a place where, as we've said at the very outset, it's been our view that what we need to do is share and coexist. That the two-row wampum belt is a very good example of that coexistence and the nature of that coexistence and how we are able to share the vast wealth. I was at the 9th European ILO regional meeting. Every 4 years, the European region meets, and I listened for 4 days to the presidents and prime ministers and finance ministers about the tremendous amount of unemployment, particularly among the youth in Europe, the European countries. And I could not help but sit there and think, this country and this region of the world is a very wealthy region relative to other regions of the world. And somehow, 500 years later, it's catching up to them. That was my thought. That wasn't probably not even true, but we always like to talk about Christopher Columbus and 500 years ago and run him down or run him, say nasty things about him. But this is a small world, and we see a planet that is under tremendous pressure. And how are we going to ensure that the responsibilities that I referred to in Article 25 to future generations, how we exercise that now? And I think that the teachings we have and the cultures that we have And the beliefs that we have, we can share that if people are willing to listen, to be able to try to minimize the damage that we see happening now, mitigate it, to minimize it, because if we don't, in my own nation we have a prophecy that is it's a long story, but the end of it is that the waters will warm, the fish will die, the land will dry, the grasses will burn. To prepare for that day, make sure the young people continue to live on the land and understand it and respect it, because in the long run, those who do understand that and know that will be able to survive. And that's what we call the prophecy of Boba. So thank you so much. Appreciate your time. I didn't sleep for 36 hours just preparing for this. I didn't sleep last night because I was so worried. Actually, I wasn't. I just couldn't sleep. Thank you.
Thank you.